All right.
Thank you. You may be seated. Good morning. This is the time set for the 5 a.m. calendar on January 28th, 2025. The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. I'll call you each one at a time to the podium, and I'll provide a second name to sit in the chair right outside of this room. If we can start with Ms. Kane to the podium and Mr. Cartwright to the chair. Good morning, ma'am. Can I get your name and date of birth?
Andrea Kane, 11/14/75.
Thank you, ma'am. And it does look like we have two cases on the calendar here this morning. The first one is a new Superior Court case, and it includes one count of dangerous drug possession, a Class 4 felony, one count of drug paraphernalia possession, a Class 6 felony, one count of driving with a suspended license, Class 1 misdemeanor, and one count of obstruction, refusal to provide a true name, a Class 2 misdemeanor. Probable cause has been found, and I am going to appoint an attorney to represent you. I'm going to give you some hearings in the downtown court. You're going to have a status conference on February 3rd at 8:30 in the morning, an evidentiary hearing on February 4th at 1:30 in the afternoon, and a preliminary hearing on February 6th at 8:30 in the morning. It looks like you have another open case, which you were out on felony release at the time you were picked up for these new charges. And because you were out on felony release on another case, you are being held non-bondable on this case tonight, or this morning. The hearing set on February 4th at 1:30 is the time set for your attorney to present evidence to the court to determine whether or not bond will be set on the new charges. Your other case is also on the calendar this morning. It looks like you missed a hearing, and they issued a warrant for that. I'm going to affirm the attorney that was previously appointed to represent you in that case and set a status conference on February 6th at 8:30. In that case, you do have a secured appearance bond of $500. However, I wouldn't recommend posting that at this time until you know if you're going to be given bond on the new charges, because even if you post that, they'll still hold you on the new charges. Did you have any questions, ma'am?
No.
Okay, if you'll step to your left, they'll give you your paperwork.
Thanks.
Can I have Mr. Cartwright to the podium and Mr. Gilbert Taddy to the chair? Good morning, sir. Can I get your name and date of birth?
Keith Cartwright, 12/7/78.
Thank you, sir. And do I have the state on the line?
Yes, Your Honor. George Kellerman from the Maricopa County Attorney's Office.
Thank you, Mr. Kellerman. And do I have counsel for Mr. Cartwright on the line?
Good morning, Your Honor. Belen Olmedo Guerra on behalf of my client, Keith Cartwright, who is in custody, appearing at the podium.
Thank you, counsel. It looks like we're here on one case this morning, and it is a new Superior Court case. And it does include 2 counts of aggravated assault, a Class 3 felony, and 1 count of discharging a firearm in city limits, a Class 6 felony. Ms. Guerra, I noticed you filed a limited entry of appearance. If nothing has changed, I'm inclined to go ahead and appoint counsel for Mr. Cartwright for future hearings, and if anything changes with you, you can file a new entry of appearance. Does that work?
Yes, Judge, that's correct.
Okay, thank you so much. So I am going to appoint counsel to represent you in this matter going forward. Again, as I just spoke with Ms. Guerra, if anything changes and you do hire her going forward, she can file an entry of appearance, okay? And Ms. Guerra, are you here today to discuss probable cause, release conditions, or both?
Both, Your Honor.
Okay. If you want to go ahead and provide me information as it relates to probable cause.
Yes, Judge. So I received the Form 4 and the probable cause statement, and I think that there is misrepresentation here because the alleged victim, the adult victim, who is alleging that Keith actually shot at these two individuals, that's completely false. And the reasons for that is because the adult victim has been abusive and in and out of the children's life. Mr. Cartwright actually has been dating the minor's mother, and he also is the father of one of the children with Bree. When Bree was unable to care for the children because she was away, incarcerated, actually Keith took guardianship of all the children, including the minor child who is said to have been shot at, and raised them as his own. Keith has been doing that and taking responsibility of raising the children. The alleged victim, George Toby, actually is the former spouse, former partner of Bree, and he has been in and out of the children's lives, not a stable father, just causing problems. And on the incident, the time in question, George appeared at their residence just to create problems. He hasn't even lived in Arizona for the longest time and just moved here from Chicago. And he just went to the residence uninvited, not a scheduled time. It was not a scheduled parenting exchange time, just to create problems. So the fact that he is alleging now that Keith would shoot at him and at the child, that is a gross exaggeration because that is not what happened at all. And so for those reasons, Your Honor, we ask the court to reconsider. There is not probable cause here to keep Keith incarcerated with these allegations.
Thank you, counsel. And Mr. Kellerman, did you have any information you wanted to provide as it relates to probable cause?
Your Honor, I don't have any information beyond the Form 4, but I think what's clear is Mr. Cartwright discharged a firearm within an apartment complex. What direction the shot was fired, I don't know, because there was no identified bullet strike. But that aside, merely firing a firearm within the city in an apartment complex that's occupied is extremely reckless and dangerous conduct. So I don't think there's any question that if the two victims were aware that a gun was fired, there's all the elements for aggravated assault.
Actually,
Thank you,
may I
Mr. Kellerman.
respond, Judge?
Yes, of course.
So there's a very big difference whether a weapon was discharged up in the air or it was pointed at the victims and there was discharge while pointing at the victims. That's a huge difference, actually. And I think we all know that the elements are very different for those crimes alleged. And that is going to directly impact my client and his case, not only for this argument, for probable cause argument, but also release conditions and the future of this case. So there's a very big difference whether there was a discharge up in the air or whether there was a weapon pointed directly at two human beings and shot at the two humans. So we ask the court to reconsider because these statements given by the adult male alleged victim are completely fabricated. And
Thank you, counsel.
the last thing I'm gonna add, Judge, is that Mr. Cartwright, I am representing him here specifically for this initial appearance because he called my office and said, I need you to help me turn myself in because there are things that they're saying that are not true, and I'm an innocent man. So he called my office on a Sunday asking me to help him, and my office and I helped him turn himself in. As a matter of fact, yesterday we went to Phoenix Police Station headquarters. They didn't want to take him in because everything was so fresh. They didn't know who it was or why should he be turning himself in. And he waited there for almost a couple of hours until they accepted him and he turned himself in. He's not a danger to the community, Your Honor, and I will make my separate argument for the release conditions.
Thank you, counsel. I appreciate both counsels providing information to the court. I have read the Form 4, and I am going to find probable cause. I am going to set a couple of hearings in the downtown Superior Courthouse. You're going to have a status conference on February 3rd at 8:30 and a preliminary hearing on February 6th at 8:30. Ms. Guerra, did you get the state's recommendation?
That was not provided to me, Judge.
Okay. Mr. Kellerman, would you like to provide the state's recommendation on the record?
Yes, Your Honor. The county attorney's office in aggravated assault cases requests a minimum of a $50,000 bond. State does not object to that being secure appearance. Thank you.
All right. And Ms. Guerra, would you like to provide information on your request for release conditions?
Yes, Judge. And again, I'm going to make the argument that the bond and the probable cause, those two things are directly going to affect my client based on fabricated statements and just pure lies from this not reliable alleged victim. I'm asking the court to reconsider $50,000. That would be an amount of money that is to secure his appearance at the next hearing during the proceedings in this case. Mr. Cartwright is not a danger to the community. He's not a flight risk. He is not a man that he is going to be leaving town. He has been working for the same employer for almost 9 years. I'm looking at the notes here. He's been working for Quail Plumbing for the last 9 years. He lives here in Arizona, and he, like I said, has cared for all the children while his partner was incarcerated. He's a family man. His father and mother-in-law have been calling me and trying to help him out because he is such a good person. He is not somebody who's going to hurt someone. He did not shoot at these individuals. He did not point a weapon. He's not going to point and shoot at a child that he has been raising as his own. So for those reasons, we asked the court to consider setting a secured bond of $10,000. Your Honor, that would secure his appearance. That's a reasonable bond. Again, he's not a flight risk, and he turned himself in. He did not have an obligation to turn himself in. He did not have an obligation to hire someone to help him, because as we know, there is no public defenders appointed for anybody who wants to turn themselves in. So he went, he hired me, he called me on a weekend for me to help him. He did not run, he did not leave, he turned himself in as soon as he learned that they were looking for him. So we asked the court to set a $10,000 bond secure, Your Honor. Thank you.
Thank you, counsel. And I have taken into consideration the 15 factors that the statute requires when setting a bond. And I did review the criminal history in this case, which it looks like at this time there are no prior felony convictions. However, we do have 5 failure to appears, and the court does believe that he is a danger to the community based on discharging a firearm in the city limits. So I am going to set a secured appearance bond of $25,000 in this case. If that bond is posted, there are written conditions of release that will include not returning to the scene of any alleged crime, no contact with any alleged victim, complainant, or witnesses. In addition to that, you would need to ensure you attend those hearings to avoid any failure to appear warrants and forfeiture of any bond that you may post. Mr. Cartwright, do you or Ms. Guerra have any questions at this time?
Is that 25,000, 10%?
It is a secured bond, meaning you can use a bail bonding company. It's generally 10% plus collateral. I usually recommend contacting a couple different bonding companies to see what each one offers because they all could be slightly different, but the general rule of thumb is 10% plus collateral. Any other question, Mr. Cartwright? Counsel, do you have any other questions?
No, Judge, thank you.
Thank you so much, Mr. Cartwright. If you'll step to your left, they'll hand you your paperwork, okay? And Ms. Guerra, you're free to disconnect or stay on here if you would like. We're going to move on to the next case.
Thank you, Judge.
Thank you, counsel. Gilbert Taddy to the podium and Lupe Garcia to the chair. Good morning, sir. Could I get your name and date of birth?
Gilbert Taddy Jr., August 8, 1982.
Thank you, sir. And it does look like we have two cases on the calendar. It looks like they're probation violation warrants, and they've alleged you violated terms 3, 4, 5, and 15 of your probation. I'm going to appoint counsel to represent you and set a probation revocation hearing on February 4th at 8:30, and that will apply to both cases. In one case, you have a secured appearance bond of $5,000, and in the other case, $1,000. So your total secured appearance bond is $6,000 between the two cases. If you post bond, you have written conditions of release. It will include contacting your probation officer within 24 hours. Did you have any questions, sir?
Yeah, I have my money, so I can't bond out.
Okay, if you don't post the bond, you'll remain in custody until your hearing on February 4th. Again, that is the probation revocation hearing and potentially a disposition hearing. They could resolve how they're going to move forward with your probation case.
Okay.
If you'll step to your left, they'll give you your paperwork. Thank you, sir. Lupe Garcia to the podium and Jonathan Sadler to the chair.
Good morning.
Good morning, sir. Can I get your name and date of birth?
Lupe P. Garcia,
And your date of birth?
1/17/1970.
Thank you, sir. And it does look like you have two cases on the calendar this morning. The first one is a new case, a new Superior Court case. And it includes one count of burglary in the 3rd degree, unlawful entry, a Class 4 felony, one count of theft, control of property, a Class 1 misdemeanor, and one count of criminal trespass in the 3rd degree, a Class 3 misdemeanor. Probable cause has been found, and I am going to appoint an attorney to represent you. You're going to have a status conference on February 3rd at 8:30 and a preliminary hearing on February 6th at 8:30. In this case, you have a secured appearance bond of $1,500. You have a second case on the calendar. It looks like you're on probation, and they've alleged you violated terms 5 and 15 of your probation. I'm going to appoint counsel in that case as well and set a probation revocation hearing on February 4th at 8:30. You also have a secured appearance bond in this case of $1,500. Between the two cases, it's a total of $3,000. If you post that bond, you have written conditions of release, and it does include contacting your probation officer within 24 hours. Did you have any questions?
No, ma'am.
Okay, if you step to your left, they'll give you your paperwork, sir. Jonathan Sadler to the podium and Ralph Ondeverde to the chair. Good morning. Can I get your name and date of birth?
Jonathan Sadler, November 3rd, 1987.
Thank you, sir. And it does look like we're here on a direct complaint that was filed. It looks like it's for an offense date of August 8th, 2024 and September 24th, 2024. And there are two counts of organized retail theft, a Class 4 felony. I'm going to appoint an attorney to represent you and set a status conference on February 3rd at 8:30 and a preliminary hearing on February 5th at 8:30. I'm affirming the bond that was set in this case, which is a cash-only appearance bond of $2,500. If you do post that bond, you have written conditions of release you need to comply with, and it does include contacting your probation officer within 72 hours. I do believe you were seen about a week and a half ago, so this would be in addition to those bonds that you would need to post, okay?
Yes, ma'am.
Any questions?
No.
Okay, just up to your left, they'll give you your paperwork. Ralph Ondeverde to the podium and Ryan Smart to the chair. Good morning, sir. Could I get your name and date of birth?
Ralph Andaverdi, 4/14/78.
Thank you, sir. And it does look like we're here on a probation violation warrant. They've alleged you violated terms 3 and 5 of your probation. I'm going to appoint an attorney to represent you and set a probation revocation hearing on February 4th at 8:30. You have a secured appearance bond of $2,500. If you post that bond, you have written conditions of release. It does include contacting your probation officer within 72 hours. Did you have any questions, sir?
No.
Okay, just step to your left. They'll give you your paperwork. Ryan Smart to the podium and Mr. Jim to the chair. Good morning. Can I get your name and date of birth?
Yes, Ryan Casey Smart, 9874.
Thank you, sir. And it does look like we have 2 cases on the calendar. Looks like they both are coming out of the town of Wickenburg. Looks like warrants were issued. The first one relates to an offense date of September 24th, 2024 for 1 count of disorderly conduct, a Class 1 misdemeanor, and 1 count of criminal trespass in the 3rd degree, a Class 3 misdemeanor. I am going to appoint an attorney to represent you, and I'm going to give you a hearing, and that's going to take place in Wickenburg. And that is going to be on February 5th, 2025 at 9 a.m. In your second case, it's for an offense date of July 28th, 2024, and it includes 1 count of shoplifting, removal of goods, a Class 1 misdemeanor, and 1 count of criminal trespass in the 2nd degree, a Class 2 misdemeanor. I'm going to appoint counsel in that case as well, and you'll have the same hearing date on February 5th at 9 a.m. In both of your cases, they've set a cash-only appearance bond of $1,000. So between the 2 cases, it's a $2,000 bond that you would need to post. If you do post that bond, you'll have written conditions of release you need to comply with. If you don't post it, they have indicated that they will, you will be made available for those hearings, or that hearing, on February 5th at 9 a.m. Did you have any questions?
No.
Okay, just step to your left, they'll give you your paperwork. Mr. Jim to the podium and Mr. Norman to the chair. Good morning. Can I get your name and date of birth?
J. Sean Jim, 1/2/1983.
Thank you, sir. And it does look like we have 4 cases on the calendar, and it looks like they're all probation violation warrants. It looks like they've alleged you violated terms 3, 5, and 15 in each of your probation cases. I'm going to appoint an attorney in each of those cases to represent you and set a probation revocation hearing on February 4th at 8:30 in the morning, and that does apply to all 4 of your cases. In 2 of your cases, you have a secured appearance bond of $500. In the other 2 cases, you have a secured appearance bond of $50. So the total secured appearance bond between all 4 cases is $1,100. If you post that bond, you'll have written conditions of release. It does include contacting your probation officer within 72 hours. Did you have any questions?
Okay, no.
Okay. If you'll step to your left, they'll give you your paperwork. Mr. Norman to the podium and Ms. Overmeyer to the chair. Good morning, sir. Could I get your name and date of birth?
Good morning, Your Honor. My name is Anthony Javier Norman. My date of birth is January 26, 1988.
Thank you, sir. It does look like we have 2 cases on the calendar here this morning. We have a new Superior Court case, and it includes 1 count of criminal trespass in the 1st degree, a Class 6 felony, 1 count of resisting arrest, a Class 1 misdemeanor, and 1 count of criminal trespass in the 1st degree, a Class 1 misdemeanor. One is of a residential structure and one is of a residential yard. I am finding probable cause and appointing an attorney to represent you. You're going to have a status conference on February 3rd at 8:30 and a preliminary hearing on February 6th at 8:30. You have a secured appearance bond of $250 in this case. It looks like you're also on probation. And when you were picked up for these new charges, that is a violation of term 1 of your probation.
Yes, ma'am.
So I am going to appoint an attorney in that case as well and set a probation revocation hearing. That'll take place on February 4th at 8:30. And you also have a secured appearance bond of $250 in that case. So it's a total of $500. It is a secured appearance bond, meaning you can use a bail bonding company. If you do post bond, you have written conditions of release. Those will include not returning to the scene of the alleged crime, no contact with any alleged victims, complainants, witnesses, and contacting your probation officer within 72 hours. Between your 2 cases here this morning, you do have 3 hearing dates coming up in the downtown Superior Courthouse. Dates, times, locations will be listed in your paperwork. Did you have any questions?
Yes, they also said that I had a warrant out of Pinal County. Does that show up?
It is not showing on my system. Officer, do you see a Pinal County warrant or hold?
I don't see it. I don't have this card with me right now. My partner took it.
Okay. It's not showing up on my system. However, that doesn't mean it doesn't exist. If they run your name and find that, they will bring you back in here for that warrant. But at this time, it's not showing.
Okay, question, because they said it's a $256 bond associated with the warrant. Can I pay that at the same time here, or do I have to go back to Pinal County? Do I have to be transported back to Pinal County and bond out from their custody?
So you would have to be seen by a judge if they do find that warrant. If that warrant does exist, you'll be brought back in here. If whoever you see at that time, whatever judicial officer is on duty, if they affirm that bond, then you could post it here and we'll give you a hearing date in Pinal County, and you would just need to make sure you attend that hearing along with the ones that I just gave you. Okay. So it would be in conjunction with the bonds I just gave you. If you get another one added, you'd add all three of them together, post that here, and then just attend the hearings. But it'd be your responsibility to make sure you get to those hearings.
Yes, ma'am. Thank you.
Anything else?
No, ma'am.
Okay, just up to your left, they'll give you your paperwork, sir. Ms. Overmeyer to the podium, and Mr. Horton Houston to the chair. Good morning, ma'am. Could I get your name and date of birth?
Kiana Overmeyer, 5495.
Thank you, ma'am. And it does look like you're here on one case. It's a probation violation warrant. They've alleged you violated terms 6 and 7 of your probation. I'm going to appoint an attorney to represent you, and I'm going to set a probation revocation hearing on February 4th at 8:30. You have a secured appearance bond of $500 in this case. If you post that bond, you have written conditions of release that you'll need to comply with. It does include contacting your probation officer within 72 hours. Did you have any questions?
I'd have to stay here until the 4th?
If you do not post the $500 bond, you will remain in custody until your probation revocation hearing on February 4th.
Okay.
Any other questions, ma'am? No. Okay, just up to your left, they'll give you your paperwork. Mr. Horton Houston to the podium and Mr. Tanner to the chair. Good morning. Could I get your name and date of birth?
Jacory LaCour, Horton, Houston, 112679.
Thank you so much. And it does look like we're here on a direct complaint that was filed, and it's for an offense date of February 25th, 2024. And it's for one count of dangerous drug possession, a Class 4 felony, one count of drug paraphernalia possession, a Class 6 felony. I'm going to appoint an attorney to represent you and give you some hearings. You're going to have a status conference on February 3rd at 8:30. And a preliminary hearing on February 6th at 8:30. In this case, you have a secured appearance bond of $250. It does mean you can use a bail bonding company. If you post that bond, you have written conditions you need to comply with, and then you need to attend those hearings. Dates, times, locations will be listed in your paperwork. Did you have any questions?
No, ma'am.
Okay, just up to your left, they'll give you your paperwork. Thank you, sir.
Thank you.
Mr. Tanner to the podium, and Mr. Albanez to the chair. Good morning. Could I get your name and date of birth?
Andrew, February 14, 2003.
And your last name?
Andrew Edward Medina Tanner.
Thank you, sir. And it does look like we're here on a direct complaint that was filed, and it's for an offense date of May 21st, 2024. And it does include one count of narcotic drug possession, a Class 4 felony, and one count of drug paraphernalia possession, a Class 6 felony. I'm going to appoint counsel to represent you and give you some hearings in the downtown Superior Courthouse. You're going to have a status conference on February 3rd at 8:30 and a preliminary hearing on February 6th at 8:30. You have a secured appearance bond in this case of $250. I believe you were seen by this court about 5 days ago. If you haven't posted any of those bonds, this would be in addition to those bonds. If you do post the bond on all your cases and you're released from custody, you do have written conditions that you need to comply with, and make sure you attend all the hearings you've been given. Did you have any questions? Okay, just up to your left, they'll give you your paperwork. Mr. Albanez to the podium and Ms. Gray to the chair. Good morning. Can I get your name and date of birth?
Manolo Albanez, 11/30/2006.
Thank you, sir. And do I have the state on the line?
George Kellerman from the Maricopa County Attorney's Office. Good morning, Your Honor.
Thank you, Mr. Kellerman. And do I have counsel for Mr. Albanez on the line? Counsel, if you're speaking, I can't hear you.
Morning, Judge. Michael Tamu on behalf of Manalo Albanez, who is in custody present at the podium.
Thank you so much. And it looks like we're here on a new Superior Court case. And it does include one count of kidnapping, a Class 2 felony, one count of burglary in the second degree, a Class 3 felony, one count of robbery, a Class 4 felony, one count of aggravated assault entering a residence, Class 6 felony, one count of aggravated assault on a victim, Class 6 felony, one count of criminal trespass in the first degree, a residential structure, a Class 6 felony, one count of unlawful imprisonment, Class 1 misdemeanor, and one count of assault touch to injure, a Class 3 misdemeanor. Counsel, I noticed you filed a limited entry of appearance. I'm inclined to appoint counsel for the next hearings, and if anything changes, you can file a new entry of appearance. Does that work?
Judge, actually, I apologize. You could actually file for me as the retained attorney. I believe I forgot to remove the limited language out of there.
Okay, thank you so much. I will correct my orders to reflect that. So I will list you as the attorney of record. And then, counsel, are you here to discuss probable cause, release conditions, or both?
Both, Judge.
Okay. And if you want to go ahead and provide information as it relates to probable cause?
Sure, Judge. So I guess we could begin with the aggravated assault under 13-1204-A5. I mean, obviously, this is a pretty short Form 4. The prosecution is alleging that my client unlawfully entered the dorm room with the intent to commit the assault, but the evidence doesn't show that, and the Form 4 doesn't show that. Actually, what it shows is that my client's presence in the room was initially nonviolent. The whole purpose was to discuss what seems to be some kind of pre-assessed debt. It seems like my client was owed $70 for some reason. And, you know, for the state to be able to prove that, they'd have to prove that the intent was to commit the assault at the time of entry. Here, there's no indication that my client intended to do so. It seems as if my client walked in, asked to be repaid the $70, and then a heated argument was an exchange because of that. So I do not believe that they have met the elements for probable cause based on the aggravated assault under A5. Moving up, Judge, would you like me to address them all at once, or would you like to address one by one?
Let's do them all.
All? I apologize.
Yes, if you could address each of them.
Yes, Judge, thank you. As for the aggravated assault under A4, I do not believe that the facts presented have my client intentionally bounding or restraining the victim in a manner that would be consistent with that statute. While the state alleges a brief chokehold during the altercation, it didn't say that the victim did not remain restrained for any significant period. There's not enough facts that allege that, including the fact that they mention a witness was present, yet failed to provide any statements provided by the witness other than a witness was present for the events. I think that if this was true, the way that the alleged statutes were, or the way that the victim had stated it, it should have stated that that the witness confirmed the victim's statements. With that being said, the probable cause statement fails to demonstrate that my client's intent was to restrict his movement to inflict harm or assist in another felony. The physical contact involved, I do not believe reaches that statute. It seems like it was a momentary and incidental to essentially that heated exchange that they had at that time. So I do not believe that they've met A4 under aggravated assault. Moving on to the burglary in the second degree, Judge, under 1507A, to support this charge, I believe the probable cause would be that the state would have to provide that my client unlawfully entered the dorm room with the intent to commit a theft or a felony. My client didn't enter the dorm room for that purpose. My client entered the room asking for his money back or the $70 debt. There's nothing that shows that my client intended to walk in there and create, havoc or cause a felony. The only thing that's showing here is that there's a verbal dispute. It's over $70. There was no intent to steal. I think it looks, and if you read the Form 4, that this doesn't even come to robbery or burglary. It's important to note that the Form 4 basically says that this is over $70, and he asked for his $70 back first. So there's nothing that shows that the state has provided enough probable cause to show that my client was planning on committing a felony with it. Moving on to the kidnapping, it's saying that the state claims that my client knowingly restrained the victim with the intent to inflict harm or felony. I don't think that there's any intent there, Judge. An alleged chokehold blocking off the door doesn't show any premeditated intent to confine or harm him, the victim. It seems like a physical altercation, and it seems almost as if it was reactive. It's not that it was calculated, as if my client walked in there trying to hurt this person. I think that the evidence shows that, and the limited evidence shows that, there was no restraint or intent to restrain anybody. The bookshelf that was allegedly caused the door closed was actually moved within the way of the door at the time of the scuffle. It wasn't something that he did premeditated in order to block anybody from leaving. So I don't believe that the state's met the kidnapping statute. As for robbery, the demand for $70 does not meet that statutory definition either, Judge. Robbery requires the proof of intent to permanently deprive the victim of property through the use of force or threats. The alleged demand, and I say alleged demand because I do not believe that it was stated the way the victim says it was. I think that this is a dispute that was ongoing over $70. My client walked in to have a conversation, and the victim essentially made this to be much more serious than it was. As I said before, it appears to be a personal grievance, not an intent to steal. He did not take any attempt. The report doesn't say that my client tried to steal the money or grab the money or grab an item in order to essentially secure the $70. It just says my client walked in asking to be paid the $70 that he was that looks like he was owed. I think the state's assertion of robbery is definitely speculative, and I do not believe that probable cause was met on that. I think lastly, Judge, I just want to touch base on the unlawful imprisonment. That charge would require the state to essentially prove that my client knowingly restrained the victim. But the probable cause statement alleges that my client blocked the door and engaged in a physical altercation. The door was never blocked. The bookshelf was moved as a result of the argument that ensued, and the victim states that he threw his hands up and turned around, which is untrue. This is not something that was caused by my client. This was an altercation over $70 that turned heated and turned into way more than I think anybody could ever imagine at this point. I think that it shows that there was a brief period where my client was in the doorway. That we're talking about a small dorm room in asking for his money. There's nothing shows that the victim was confined to the room. I do not believe that the probable cause was met there.
Thank you, counsel. And Mr. Kellerman, did you have anything to provide as it relates to probable cause?
No, Your Honor. I believe, and I'm sorry for the echo. I don't know what's going on technically. But defense counsel has eloquently addressed the formal charges. And what I would say is that what is formally charged in this case, I believe, will be significantly different than the booking charges. And as I see it, there's an alleged debt. Mr. Ibanez went there. There was a physical confrontation without particular violence or injury. And I believe that what we're dealing with is essentially an assault. And so the state would not object to him being released, that he have no contact with the victim, and that he not return to the incident location. Thank you.
Thank you, counsel. I appreciate both counsel's information relating to probable cause. I do think counsel for the defendant does have some good points as it relates to the defense of this case when it moves forward at trial. I do think we have enough today for purposes of probable cause, so I am going to find probable cause. But then we're going to discuss release conditions. It looks like Mr. Kellerman just provided the state's recommendations. Counsel, did you have any request as it relates to release conditions? Are you in agreement with the state's request?
Yeah, Judge, I mean, I would just be requesting that Mr. Albanez be released on his own recognizance. I know that Your Honor, you are finding probable cause just for purposes of this hearing. You know, my client is just turned 18 years old. He's got a 3.8 GPA at the Arizona State University. The only thing that I would request is that Mr. Albanez is able to attend his classes if there are classes in session. And essentially, he be not allowed to return to that dorm room.
Does he reside in the dorms?
I believe so. Is that? And my client can answer that question.
I do.
And do you reside in the same dormitory hall where this incident took place?
No.
Okay, so it's a completely separate building?
Yes.
So you could still return to your home and attend classes even if I made the ruling that you couldn't return to the scene of the crime, which would be specifically that dorm, is that correct?
Yes.
Okay. All right, so what I'm going to do is I'm going to go ahead and release you to pretrial services. What that means is when you get your paperwork here in a minute, you're going to have release conditions. It will include not returning to the scene of the crime relating to that dorm, no contact with any alleged victims, witnesses, or complainants. And then you're going to get an envelope with instructions. Read those. Once you're released, there'll be a phone number to contact pretrial services. They'll provide reminders and anything you need as it relates to getting to these hearings, okay?
Okay.
Did you have any questions?
No, Your Honor.
Okay. Does either counsel have any questions?
Not from the state, Your Honor. Thank you.
No, not from the defense. Thank you so much, Judge.
Thank you. I appreciate you both. This hearing will now conclude, sir. If you can step to your left and take a seat outside, we'll reprint your paperwork and get that to you. And both of you are free to disconnect if you would like.
Thank you, Judge. And Judge, if may I just ask my client, is it okay for me to speak to your father regarding some of the facts of the case? Mr. Albanez?
Yes.
Okay, thank you.
Yeah.
All right, thank you, Judge. I appreciate that.
Absolutely. Have a good rest of your day.
Thank you. You as well.
Thank you, Your Honor.
Thank you. Can I have Ms. Gray to the podium and Ms. Bowers to the chair?
Great. Great?
Yes.
Come on in.
Thank you.
Thank
you.
No, sit just up there. Take it easy. No. I'm driving. Take it easy.
Good morning. Can I get your name and date of birth?
Brianna Gray, February 9th, 1989.
Thank you, ma'am. It does look like we're here on a new Superior Court case. It does include 1 count of dangerous drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. Probable cause has been found, and I'm going to appoint an attorney to represent you and give you some hearings in the downtown Superior Court. We're going to have a status conference on February 12th at 8:30 and a preliminary hearing on February 14th at 8:30. I am releasing you today to pretrial services. They'll give you paperwork that includes your written conditions of release, dates, times, and locations of those hearings, along with an envelope with pretrial services information, and you'll need to contact the phone number listed in there once you're released. Did you have any questions? Okay, if you'll step to your left, they'll give you your paperwork now.
Thank you.
Ms. Bowers to the podium and Mr. Martinez to the chair. Good morning. Can I get your name and date of birth?
Karita Bowers, 42975.
Thank you, ma'am. It does look like we're here on a new Superior Court case, and it includes one count of theft, a Class 6 felony. Probable cause has been found, and I'm going to appoint an attorney to represent you. I'm going to give you some hearings in the downtown Superior Courthouse, and it's going to be a status conference on February 12th at 8:30 and a preliminary hearing on February 14th at 8:30. I am releasing you today on your own recognizance. That's your promise to appear at that hearing. You'll also have written conditions of release. It will include not returning to the scene of the alleged crime, no contact with any alleged victims, complainants, or witnesses. Did you have any questions?
No.
Okay, just up to your left, they'll give you your paperwork. Mr. Martinez to the podium and Ms. Lechuga to the chair.
You want to go to questionnaire or no? It's your turn. It's on you, sir. Your pleasure, please.
Good morning. Can I get your name and date of birth?
Nicholas Martinez, 12/14/2000.
Thank you, sir. And it does look like we're here on a new case. It looks like it comes out of the Surprise Municipal Court, and it does include one count of disobeying or resisting an order or mandate of the court, a Class 1 misdemeanor. Probable cause has been found, and I'm going to appoint an attorney to represent you. I'm going to set a hearing in the Surprise Municipal Court for a Class 1 misdemeanor. Probable cause has been found, and I'm going to appoint an attorney to represent you. I'm going to set a hearing in the Surprise Municipal Court for an arraignment hearing on February 25th at 1:30 p.m. I am releasing you today on your own recognizance. That's your promise to appear at any hearings. You have written conditions of release you need to comply with, and you need to ensure you attend that hearing to avoid any failure to appear warrants. Did you have any questions?
No, ma'am.
Okay, just up to your left, they'll give you your paperwork. Ms. Lechuga to the podium. Good morning, ma'am. Can I get your name and date of birth?
Rebecca Lechuga, March 12, 1997.
Thank you, ma'am. And it does look like we're here on a new case, and it comes out of the Surprise Municipal Court, and it includes 2 counts of assault and 1 count of criminal damage. Probable cause has been found, and I'm going to appoint an attorney to represent you. And I'm going to give you a hearing in the Surprise Municipal Court. It's an arraignment on February 25th at 1:30 in the afternoon. I am releasing you today on your own recognizance at your promise to appear at that hearing. You are going to have written conditions of release. It does look like you reside with the victim, the alleged victims in this case. Is that correct?
Yeah.
Okay. So you are not going to be able to have any uninvited contact with them. So if the alleged victims in this case consent to contact and consent to you returning home, you can do so. But if they ever revoke that consent, then you would have to find a temporary residence while this case is pending, okay? All that information, date, time, and location of your hearing will be in your paperwork. Did you have any questions?
About the going home part, so I already called them earlier and they said they were going to come pick me up. Is that okay?
As long as they're consenting, as long as they're okay with that, then you can.
Okay.
You just, if they ever say they don't want to have that contact, then that's when you would have to stay away at that point, okay?
Okay, thank you.
Anything else?
No, thank you, Your Honor.
If you step to your left, they'll give you your paperwork. Case number 27, Clay Price, date of birth April 19th, 2001, will proceed as a house call due to being a danger to self. We are here on a new Superior Court case, and it includes 1 count of criminal trespass in the 1st degree, a residential structure, a Class 6 felony, 1 count of criminal trespass in the 1st degree of a residential yard, a Class 6 felony, and 1 count of criminal damage, a Class 2 misdemeanor. Probable cause has been found, and I am appointing counsel in this case. I'm setting a status conference on February 12th at 8:30 and a preliminary hearing on February 14th at 8:30. If anything changes after I meet with him, I will update the written record. I am releasing him on his own recognizance. That's his promise to appear at that hearing. He will have written conditions of release, which includes not returning to the scene of any alleged crime, no contact with any alleged victims, witnesses, or complainants. Case number 3, Gerardo Soto Reyes, date of birth November 4th, 1996. We're here on a new Superior Court case, and it does include 2 counts of aggravated assault with a deadly weapon, a Class 3 felony, 1 count of domestic animal cruel mistreatment, Class 5 felony, and 1 count of criminal damage, Class 2 misdemeanor. Probable cause has been found, and I am appointing counsel to represent him. I'm setting a status conference on February 3rd at 8:30 and a preliminary hearing on February 6th at 8:30. I'm setting a secured appearance bond in this case in the amount of $50,000. If bond is posted, he has written conditions of release, which include not returning to the scene of the alleged crime, no contact with any alleged victims, complainants, or witnesses. He may not possess, reside with, or have any contact with any animals, whether or not he owns them or not, and he must obey any terms of any order of protection that has been issued or may be issued in the future. If anything changes after I meet with him, I will update the written record. We will now stand in recess until the 8 a.m. calendar.